Firstly, I look at your faces. Don't look serious. This is not going to be another class of yours that you have already quote and unquote suffered for last 5 years. Let us begin with a hypothesis, an assumption. I really want interactions with all of you. A is an advocate, not so good advocate. Let us say he knows that I'm not a very good advocate. He's very aware of that. The B is a very good advocate who knows I'm a very renowned advocate and I have a lot of names in my area of practice. And even the A also knows that B is a very good advocate, right? We know that, when an advocate who himself knows that I'm not so good, how he looks at the other person who is good, right? A got a case. In a court, he is arguing it very miserably. That's normal. He is not a very good advocate. Now, let us assume that that was a matter relatable to, say, termination of service. I mean, some of you must be aware of that, service matter, termination, etc., involving a livelihood, life of a person. A person also means a family, etc. Let us have one more assumption. A has absolutely no knowledge about the service law, right? The judge asked him a question, he failed to answer. He knows that this is not his cup of tea. He was with lots of nervousness, etc. But somehow he could manage to get an adjournment from the judge. He felt good about that. Incidentally, the client was present in courtroom. He could see the great performance of his lawyer. I hope you understand the great performance. Now, the B was also there as one of the, as other advocates being in the present in court. And B felt bad because B is an expert lawyer. It's a very renowned. He said how miserably A was doing that. So, he didn't say, but inside his mind, you are free to say anything and everything. He felt that this is a simple matter and he could not even take this point. Incidentally, and because of our story of this assumption, the client has gone to B, made a request, he said, can you please appear in this matter because I have seen the great performance of my lawyer. And look, I have a family, I have a kid, I'm going to lose my job. And I don't know what I'm going to feed my kid. So everyone says that you are a very good advocate. Can you please appear? The B says, how can I appear? Because you already have an advocate. I can't appear. Then what happens? I think we also come across it. No, sir, please, these, that, persuasions. And B happens to be otherwise a very soft-hearted person, right? He really felt, look, true, this man needs an expert, a lawyer in the field. And he is actually an expert. And he's a very good-hearted person. He says, well, fine, okay, since you were saying, but I won't be taking a fee. Because you already have an advocate, you will be there. So this would be a philanthropy. That means, something for like a service. So I won't take a fee. I will be studying the matter. The next time when the matter is called, I will argue the matter. Done. So client was happy. Next day the matter was in the list. Now this part was not known to A, the great lawyer. right, with a great performance. When the matter was called, B, that's the good expert lawyer, he came there. And you need, if you look at the psychology between the two lawyers, because he knows that B is a very good lawyer, right? And B starts arguing. And successfully. Both of them won the case. Because A didn't say anything, because it was a big surprise to him. But the fact he was aware of that B is a very good advocate, and therefore, and he also knew I had a miserable performance, so he was silent on that. And he also got his fee, another major material factor in the matter. Now B argued the matter, the judge was very convinced, and the livelihood I am saying because the termination of service, say that was the subject matter, could be saved. So this is the assumptions we are beginning with. Now I want you to apply your mind. Don't look at the book, don't think about the legal ethics, etc., whatever you might have read. Just let me know, like, how many of you think morally the B did the right thing or the wrong thing? Just feel free. I'm not asking, because this is not a quiz contest kind of thing. I want you to begin with your own thinking, right? Once you start thinking liberally, then I will also start thinking liberally. And we together, we may try to find out what suits best as a human being, Homo sapiens, and whether there is a conflict as an advocate also. We will see from a practical point of view. So, as I said, okay, you are smiling, so why don't you begin? What do you think that, first you say that, did you feel that there was morally, because let me give you a little more picture, it will be easier for you. Look, because B argued the matter, his family could be saved. B did not take any professional fee. B studied the matter. He had a soft heart. He is otherwise a good human being. That's why he felt for the client. He could foresee the person is going to lose the job. So he basically helped, right? So what do you think about it? Do you think it's morally he did the right thing?
It was the right thing to be done to the client, but as a fellow advocate, I think like it would have been harsh on the advocate A. A better scenario would be had we talked and advised and did a briefing and then made him argue the matter, because that is how A would have grown as a lawyer. He would have gotten a senior expertise.
Absolutely. So to begin with that question, so moral point of view, look, you are also saying yes, isn't it? So morally, there was nothing wrong on the point of view of the B to extend his expertise, and that too by sacrificing time, sacrificing money. And that's a great answer, because I want to begin with not, look, in the book it is said yes and no, don't apply that, don't become a robot. Let us make mistakes, doesn't matter. There is nothing called mistakes also, I mean, if you go deeper. All I'm saying, so you think morally, nothing wrong in that. Anyone else who thinks here that even morally this was wrong? I'm not saying legal. Yeah, say.
So I think morally it was wrong because that becomes a scenario of brief snatching. First of all, when an advocate A was appointed, So first of all, he should have approached the advocate A and asked for an NOC, or that he could have extended that, sir, I will be assisting you, that client has come to me also. But there should be transparency between the fraternity. Once there is no transparency between the fraternity, I think it does not help much. Because at the end of the day, even if you're doing it for free, that would also be wrong, because at the end of the day, you have to go back home and feed your family. So you cannot do everything for free also. My mind is my money. My time is my money. So without getting in touch with Mr. A, he should not have gone forward with it.
So therefore, you feel that, let me just say for the
Morally
sake of
also wrong,
saying-
sir, as an advocate.
Exactly.
The morals of an advocate differs from the morals of a human. So in the morals of a human, he probably did the right thing by helping the person. But as an advocate, I think he did not do it morally right also.
So therefore, let me say a little bit of against you, because look,
Yes, yes.
all of us here advocates, you love this kind of things. So don't take it what I'm saying that that's my thinking.
Definitely.
So you think that there is a morality for Homo sapiens, and there is a morality when the Homo sapiens wears black and white, the
And he
robes,
becomes a professional, right?
right? So you feel that the morality which is not tangible is different the moment you are an advocate, right? Fine. Now, as I said, we are not going to have a lecture like I have studied something, I will tell you something, because it doesn't work. It doesn't work. Rather, our effort should be so that we can genuinely and we can liberally think couple of things, and if you can inculcate some kind of curiosity, because no one can teach you unless you really want to yourself. If you have curiosity, no matter you don't have a book, you don't have a senior, you don't have anyone to ask, you will find it out. Correct? So entire effort is for that. Now, the fundamental question, we take both the opinions, and both are absolutely fine. But since our topic is something to do with the duty and ethics of an advocate, right? And let me put it this way, this is also my thinking. If you go deep, you are basically a human being. No matter you are a lawyer, another was a doctor, another one is a beggar, and someone he may be a dacoit, another is a terrorist. But it's only the same thing, there are inside proportions are different. But the principles of morality are very subjective, right? Today we have a morality of one person's, you have a morality, I might say, of a different. So each one of us has got a morality which is subjective. By saying subjective, what I meant is very individual, very different. Correct? Now let us begin with that. This part, I think we are agreeing with that. The morality from this hypothesis, not only from this hypothesis, but everything, it is very subjective and individual, right? Now we are going to talk about the ethics, duties of the advocate, correct? How it is related of the individual subjective morality. Let me give you an example, real examples, then you'll understand why what is the purpose of this hypothesis. You are sitting, all of you now. What do you see now? Simple question. No, not me. You are seeing the wall, you are seeing this microphone, you are seeing many things, correct? All of you? So if I give half of you a microscope, so those half would be seeing the millions of other things, other half will not be able to see that. Let me ask you a question then. What is truth? The persons who are seeing with the microscope the millions of other things, is it the truth? Or the truth is only this person, this podium, this camera, this etc. etc.
Truth is also subjective to perspective.
Yes. So let me put it the same thing in a different sentence. The truth is dependent on the tool that you are using. I hope we are agreeing on it, right? Because if I give you the microscope to everyone will be able to see all the millions of bacteria, correct? Will be on the same scale. So let us take that as a metaphor. Ethics of an advocate. What's ethics? Or the duties? Let us put it, ethics is a big word. Let us say do's and don'ts of the advocates, correct? Simple. Do's and don'ts, there is a prescriptions by the legislatures, by the creature of the legislatures. So the do's and don'ts of the advocates, let us take it as a tool. So one tool to everyone. Now how does it help you? The truth with half of you having the microscope was different. When you contrast it with the other half who don't have that tool. But when you have the tools, and if that tool gets into you, when I say gets into you, it's the program is the sensitizations. It's not like copy pasting thing. I give a dialogue, you read or understand by heart some part of it, and you thereafter forget some other part. Not like that. If something seeps into you, goes into you, and if that something happens to be a common, then the divergence in the truth are likely to be less. So therefore I am not questioning, because I would like to say that it is absolutely fine to have different moralities, different thought, divergence of opinion. It is absolutely fine when you say it's good, nice to have a good heart. Extend, because that was the only way to save that person. So he might have thought about the family, the client, something transcending his profession only alone. But the other, as you said, no, the morality was of the advocates different, so he could not have done it. Both are absolutely fine. But instead of thinking individually, you can do some other thing. In the morning you go to court, right? Minus Saturday, Sunday. You wear dresses. Correct? How much of time you take to decide what to wear? 5 minutes, 10 minutes maximum. Take the example of you are going to a party, a celebrations, maybe a date too, right? How much time you will take to decide what to wear? Much more. Correct? So, when you are using your subjective individual judgment, you are spending lot of energy of yours, right? I have to go to a birthday party, so my wearing has to be suiting to that. I am coming for a program in a judicial academy. I can't wear a t-shirt. I have to have something for, I'm saying about myself, right? So I have to wear something formal in nature. So no one is helping me. I have to decide what color. Should I be wearing a red? No, it won't suit properly. So I am using my own morality judgment to decide, correct? Now, if I have a prescription, let us say that way, of do's and don'ts. Let us take an example of that assumption. The assumption was that subjectively two things are fine. Morally fine to save a person, but also morally not fine because of you have to take a consent of the concerned advocate, correct? But instead of that, if you have a prescription specifically saying without the consent of the advocate on record, you can't appear. Number one. Number two, if you appear, you may face a consequence. You know the consequence. Because very recently there has been many judgments on that. The consequence is you may lose your license. Your license may be suspended because it is a misconduct. Now come back to the assumption again and look at with the better informations. All I am saying, if you have a prescription, that opens up your eyes and it helps you to think that yes, I am feeling for the client, but because of the prescription, I might be facing a disciplinary proceedings because this is not permitted. And let us take an example, let us stretch it, as an advocate, we love to stretch. If I am suspended, I might even lose to appear from say 100 others for whose livelihood I can also save if I am a good advocate. So therefore, the biggest flaw in that subjective morality that we assumed, number one, the B is a very good advocate. You remember I said, but do you find it in real life? Do you really find that every case which you find to be good, you are successful? You don't find that. Life doesn't go in that way. The worst case you are successful, the best case as you think, you might face some difficulty. So therefore, in real life, there is actually no such assumptions. Correct? So drop the assumptions. In real life, you have a prescriptions of do's and don'ts. Similarly, in real life, just like morning schedule, I don't need to think about which color I'm going to wear. Better, I don't have to waste my energy to decide, is it morally right, is it morally wrong. I don't need to. Let me look at what are the ethics and duties of the advocate. If it is in sync with that, great, go ahead. If it is not, I'm not saying stop it, it's up to you. You may say that I love to be punished. That's your choice. I'm trying to say be liberal. Don't take a decisions without knowing that you can be punished. It's up. Look, remember one thing, we have thousands of laws. It doesn't mean that those things don't happen. You have the criminal law. It doesn't mean that there is a zero criminal acts. No. So let us not live in utopia that because there is a law, because there is a prescriptions, so everyone is going to fall. Not that. I'm trying to say, once you get to know both sides of the story, that if I do not follow the do's and don'ts, there are consequences. Then it's your choice. And I said curiosity is this, that the question could be that what's the need? Because as a lawyer we are basically absorbed with other problems. I don't know what's about you, at least it's very true to me that I didn't see Advocates Act, because of this program I read it so thoroughly. That's the truth. Yeah. And then I realized many of the things I actually follow, but not necessarily by knowing it. But that was my subjective morality. Incidentally, that was in sync with that. But there may be divergence. So therefore, I hope now, I don't know, I just expect that now you may think that, okay, I am now a little bit curious to know the do's and don'ts. Because that can save my time. That can save my energy. I don't have to apply my mind on the morality to decide each and every sequences or the situations that I face while, journey of my professions. So let me sip a little bit of tea, and all of you also, and then we'll continue. So this is only for the purpose that you yourself must feel why you need to know the ethics. And I believe the only reason, to me, To you, it can be not only, many others. To me, the only reason is that I get to know. My eyes should be open. I don't want to suppress my morality decisions, but I must know that am I going for a morality at the cost of something else? Then I will take a better informed decisions, right? So please have your little bit. Follow the ethics. Okay, I got your answer from your smile. Yeah, that's the truth. Because when I started seeing the book and I was thinking, I'm not really very much interested in the books. Because I feel that there is a lot of difference between what you are taught and what actually happens in real life. If you really copy paste what you are taught or what you read yourself, I mean, this would be disastrous.
So, sorry to barge in.
Please, never, by the way, never feel sorry.
I
Because
think
then-
everybody feels the same way. Ethics, as you asked, and how many follows. Right now, through the experiences we've come through, I think this is also very selective, and the application of the ethics also is very selective. I mean, like A and B comes into the scene.
Yeah. True. It is very selective. Because you have to accept your pros and cons, right? All of us have the potentiality to be very good. That means you also have a potentiality to be very bad also. Correct? So therefore, when you analyze a thing, if you ignore the so-called negative part of it, then your analysis would be very bookish in nature. For an example, say the young lawyer, correct, who is struggling. I'm just giving an example. Who is struggling, and struggling in a sense, in a very, very, very serious struggling. He gets a fee. He can't afford to lose a client, which is very important. Maybe the way he has got that fee may have a conflict with the ethics. Simply if I tell, or if any one of you tell him, look, in the ethics it is said, so don't do that. This will not work. Let us admit that this will not work. Because that ethics part has to go into his system. In the similar manner as I said, that in the morning just the black and white or whatever the dress code. So I hope there is no confusion on that. You never think that I'm going to quote, I have to wear a t-shirt. You don't think that way. So therefore there is a less confusion. You don't lose any energy on that. So that way, if we build up our ethics structure, I mean, I like the word sensitization. We say this, then I try to find out. Because every word that we say, most of the times we really don't understand. If you look up the dictionary, you will find any word that you often know. The moment you look up the dictionary, you will find the way it is explained. And if you spend a little bit of time with that word, you will be able to see many things which you have otherwise missed. That's the same thing with the law. Like sensitizations, I could see that it is basically to become sensitive. We are aware of that. If you are sensitive, your action would be automatic. I felt, oh, so good. So I have to be sensitive towards the prescription. Correct? But I don't know how. It's great to say that if you are sensitive, then automatically you will respond to that. But then I thought the how could be, if I feel I need it. Because unless you feel that you need it, you won't do it. If I tell you that, look, that's great, you will smile on me because everyone is seeing, you have to smile. But you won't do that. But you will only do when you actually need it. Not only do, I mean, you, even if someone says don't do that, you will do that. So therefore, this sensitization is possibly more of finding out whether do we need to know this? Does it help us? I'm not giving answer because I really don't have clear answer. I mean, I have some answer because I have, I have studied little bit for this. I would like to have the walk with all of you to find out whether really all of us, I mean, myself included, need it or not. What time we started? Just for calculation of some time.
We start 10:30.
Okay. Time passes.
So can I ask you a question?
Just one.
Yeah, just one. I'll try to make it difficult.
Please. I expected.
So sir, I want to ask
No,
you
don't
what
make
is-
it, look, don't make it difficulty for the sake of making it
No,
difficult.
एकदम नहीं ऐसा.
Yeah, make it difficulty if it is, good for our journey.
So in your
Yeah.
experience, or like given of what you have faced, what do you think that junior lawyers like us, who when we stand in front of the judge, our leg shakes at a Richter scale of perhaps 6, that we've been hit by an earthquake, we we cross this code more times, or actually this is surpassed by the seniors most of the times?
Where is the director?
I looked at him, he was not there, that is why I asked this question.
No, because in fact he was telling me some problems being faced by the juniors, which was very much something like that, right?
We are directed by somebody to go and ask something.
It's a great question in a sense. Nothing to do with this topic. It's not needed because this is connected. Let me stand and see. Okay, I will have a little more energy. I really don't know what I'm going to say, right? Because I'm more into kind of spontaneous kind of thing, because that's also in the code. Look, let me give you answer what I genuinely think in the process of, as I say. Right? I might change also. First thing is, you see, each one of us has some individual talents, and most of us are probably not aware of that. Like, I may not know that actually, I am a vast speaker. Actually, I am not a speaker. I mean, I don't do public speaking. I believe this is the first time I am having a public speaking. Somehow it doesn't suit me well. So, but every one of us is actually good at something. Good in a sense that for that you don't have to spend time much. You will find some of your friends, they pick up, any line of a song so quickly, and you feel really depressed in a lighter sense. Oh, I am so dull. He could do it within 2 minutes, and I am not even able to remember what was the lyric. I am there. Now, I have found there are some persons who are good at mathematics. I can share one experience of mine. We are going to Delhi for a case. With me, there was one secretary. It's a long days before. He loves mathematics. You see, usually most of the lawyers hate that. He was, in airport, we had a lot of time. He was doing mathematics there. He was not reading a literature. He was not reading any magazine. He was doing mathematics. He said, I'm feeling good. So I won't say, the reason of saying this is that not for every one of us, this profession is the best profession. Let us accept it clearly, correct? Let us not give you an answer which is very, I don't believe in. So some of us are really okay with facing the judge. And facing the judge is not necessarily, it varies. You really feel bad not because when you lose. You really feel bad when you feel very humiliated, or you feel that your sense of justice is totally shattered. That's the truth. You don't feel bad when you give your heart, you do a matter, and even if the judge gives you interpretations which is different, you respect that. But you only feel bad, that is wrong, correct? But tell me anything in life that happens that, I believe that wrong part and the right part is there is nothing wrong and nothing right, I tell you. But there is both put together is what you have, you call it life or whatever it is. So coming back to a direct question, there is no magic answer to that first. You will have no one to tell you, no one to give you a tablet, you take that pill and next morning you are super confident. That will never happen. But the only way could be through. You get it? When I say only way through means that, say you get an opportunity to appear in a matter, correct? So you are totally nervous. What happens when you are nervous? You suffer. Now why do you think that suffering is bad? Suffering is lesson. You feel terribly bad at that point of time. But say after 5 years or 10 years, you will remember that day. Because of that suffering, I got a lesson. Let me give you another. I think you look all very young. You can be able to, relate that. Say you are in college, right? Say you have a breakup. You feel very sad about that. Some of you would be crying. Some of you would be showing a brave face, but inside crying, right? You will feel that's the worst day in my life. After 10 years, you might even say, oh, that's the best thing happened in my life. That's a turning point. That's why, I chose this. So the question is not, don't look at from that point of view, that you're suffering, you're shivering in the courtroom. As I said, only way is through. There is no other way. I remember the first day I appeared, I remember the judge also, Justice V.K. Gupta. Incidentally, in that matter, the lawyer was Deepankar. He is now one of the Honorable Supreme Court judges, one of Honorable Justice Deepankar Dattu. So he was led to come, and it was my first appearance. I could not even speak for 1 minute. That's the truth. I couldn't find that how this can happen. And I thought that then all the lawyers are basically rocket scientists. I am so dull, not even able to say what I have studied. That was my feeling. And today I don't have that feeling. Now then, what magic pill I got it? There is no magic pill. Next time I appeared, it got listen little, that little. These are the general thing, but some a little bit of other thing you can look at. If you are prepared with something, your chance of nervousness, somehow, I don't know what's the connection. I have found that when you put in your more time, more heart into the matter, something good happens to you. I can't explain how it that. Not necessarily good means that by being successful in the matter. Even if you face a very difficult judge, tough questions, even then also I find that when you have actually studied your matter, you have put in a lot of efforts into that, you have some kind of better situations inside the courtroom. So, last one sentence. Really, there is no clear-cut answer on that. But because you are nervous, that means the persons who you are aspiring, oh, this advocate I know, I like him. That person also had the similar thing. So you are on the same track. So you can take it, this is a nudge. It's a biological nudge to you that look, this is the process without which I won't let you go somewhere where you want to go. So let us come back to ethics. Now, I hope now we have got some sense of, I won't say curiosity, at least something in mind that let us explore that why we need it as we sit. The reason simple. Let us try to make our life smoother. Life means not entire life. That you have to do. That's professional life. So now what we'll do that we will take each of the do's and don'ts and we will discuss on that, right? Because that way it might seep into us. Now, just a basic things, because I don't like to say much about the legality in these sections, this, that, because you can read that yourself. Just a basic things of the Advocates Act and the Bar Council is that, just remember it. Don't look at any of the books. Is that we have a legislations. What is the source of that? In the Constitution. In the Constitutions, there are 3 sources for making legislations. You know that. One is exclusively by the Union, that's central. 2 is exclusively by the state. 3rd is, by both. This belongs to 3rd. Just for, basic. Now, Advocates Act, it has several sections. Just remember that there is a body in every state, the body which is going to control you and where you will get yourself enrolled. That's a state bar council, right? And there is a, if I can call, a super body, the Bar Council of India. Remember one thing, if there is a complaint for any of the violations on ethics, don't think that your, I wouldn't say smaller body, the state body, that state Bar Council, only they have an exclusive right or the power. The Bar Council of India, even they can take up that matter, and there are provisions also, say if it is pending for 1 year, it will automatically get transferred there. So that's why I said it's a super body. They have a lot of power, they can punish you, they can suspend you, they can remove you, lot of things. Now regarding, before that, by the way, any one of you know that how many classes of advocates? Okay, you don't have to answer, I'm saying you. There are, I'm saying statutorily. If you look at section 16, you will find it says there are 2 classes of advocates. In fact, a large chunk of lawyers are not even aware of that. You see, advocates means advocates, that's all. No. There are 2 classes of advocates. One is the senior advocate. Other is, the language is other advocates. That's the language of the section. Senior advocate and the other advocates. Now, who can be a senior advocate? This senior has got nothing to do with age. I often find it difficult to make people understand. Now, this senior advocate is that when the Supreme Court or the High Court designate, it's something like they decide, all the judges sit together, they decide these advocates should be designated as a senior advocate, they become a senior advocate. The do's and don'ts of a senior advocate are different from the do's and don'ts, rather I would say much more than the do's and don'ts of advocate. So let us go to do's and don'ts, right, of the advocate. Now where do you find it? You won't find it in the Advocates Act. That's there mainly in the Bar Council, they frame rules. There are so many rules so far as the do's and don'ts are concerned. So I would be showing you a couple of those. and we will read together and we will have a grand conversations, I wish. Others, in Bar Council India rules, can you come to page 62? Yes. So this regarding senior advocates part, I will. This is very small part. Okay, let me finish that. The do's and don'ts of the senior advocate. So many. Firstly, a senior advocate cannot sign in the Vakalatnama. If he does, it's a misconduct. A senior advocate cannot appear in court without any other advocate. I often you see that gross violation in many of the courts, but statutorily this is a misconduct. A senior advocate also cannot draft, remember it. It's a very difficult situation. They can settle. So, drafting has to be done by an advocate. Look at the issue. So, I will tell you where to come. So, when a drafting comes, that means drafting is done by an advocate. It is given to senior advocate. He can settle. So let us assume that a senior advocate, makes a bill for drafting. It's a misconduct. There are a couple of other little. It's not the don'ts. There are do's like that. He can take a decisions, more weightage. But that's not that important. Now there. Yes. There is this, just for your information purpose, don't give it a thought much, just information that you will find it in chapter 2, part 6. Just to reduce your confusions, when you read the Bar Council rules, it will confuse you a lot. Because when you read the legislation, you see sections. When you read the rule, you see rules. But in the Bar Council rules, you will find both. And there are so many chapters. So it will confuse you a little. So we don't have to go into that confusion. Just remember that when you see that part 6, chapter 2, there are your do's and don'ts come. Now there is a preamble. I would like to read the preamble, not now. We will do just the reverse. The beginning will do the last, right? So first is come to duty to court. Yes, that's a thing. You can read there from now, because first I would like to read, then we will discuss with open mind, correct? Number 1. An advocate shall, please this part I would want all of you to read, right? An advocate shall, during the presentation of his case, and while otherwise acting before a court, conduct himself with dignity and self-respect. First, he shall not be servile. Remember, the word servile is basically, I think you will quickly understand, it is more like a slave. There are some people you see always ready to please you. That's a characteristic of being servile. So advocate, something like a good combination of independence, but not, arrogance. So, and whenever that part, that's basically they have put it in one sentence, but that's a very serious thing. We'll just, cut it down here, and we'll first. So anyone, please say then, as an advocate, what you find the most important 2-3 words here? Any one of you?
Dignity, survival.
Yes, anyone else?
Duty.
Yeah, because be little louder.
Duty.
Yes, duty. So you get that conduct himself with dignity and self-respect. Let us first focus on that, because What does it mean? I think all of us, we understand it. That is enough. We don't have to always, put into words, because the understanding is the main thing. So it's fundamental part of it that you must maintain your self-respect. You just take a middle path, that's in a Buddhist philosophy, we have a middle path. You take a middle path. Don't try to be a yes man or yes woman all the time. Neither, always you have to be in an attacking attitude. And this self-respect, dignity, it's not just outwardly. It's not that you have a good, non-shabby dress. Of course, you must have a good dress, that's required. But remember, when you present a case, simple things can be said in different ways. So be respectful to that. I think this part is not very complicated. It is, we understand. There are some advocates, I think this way you'll be able to understand. There are some advocates who you actually admire, correct? I hope some of them, they maintain that self-respect, correct? So just get that. So you should not be arrogant. And let me give you an example. The court is asking a question. Say the question could be something like that. What day it is? You don't have an answer. You say, we are living in India. Deliberately you are answering what you know. So it doesn't take you anywhere. You actually somehow, irritate the court. For an example, you don't know anything. I'm not saying that it will ensure you always a good result, but it will ensure that you don't lose your dignity and respect. If you say that, my lord, I do not know this, please adjourn, I will prepare on that. It is possible the court might rebuke you a lot, but still, instead of doing that, you spend 30 minutes time and you say all the blah blah, and you know yourself that what you are doing is absolutely neither here nor there. So these are not self-respectful. So therefore, that sense of things we should have. And not be servile, I think we know that. That you shouldn't be always yes man. For an example, a question is put to you by the judge, and it's not necessarily you have to agree with that. Like you said, it's not necessarily that what I'm saying you have to agree with that. You can respectfully disagree. You can give your thing. Maybe some people, because of some reasons, are not able to digest that. That's true, I know. I am aware of that. And we try to avoid that. So there you have to, at what point you have to leave, at what point you have to say, you have to decide yourself. Now the second one, this is something very dangerous part. Remember it, because there are judgments on that. And then when we go to the judgment part, I will explain in detail. And whenever there is proper ground for serious complaint against a judicial officer, it shall be his right and duty. Remember, right I could have understood. Now it says also it's your duty to submit his grievance to proper authorities. So what it says, if you find a judicial officer is not doing right, is doing nothing to do with merit of a matter, you know what I'm saying, then it is also your duty and right to take it before the proper authority. Proper means higher authorities here. But here, look, this is what is prescribed now. But I would request all of you to apply your own mind. Remember, it's your life, it's your profession. There is an example of one of the advocate records making a complaint with the registry in the Supreme Court, and that judgment is there. He was hauled up for contempt. He was punished under this Advocates Act. So he suffered. Now, I would say on this count that true, there is a prescription. But unless you find that there is no other alternative, all doors are almost closed, don't explore that. You know what I'm saying, it may be little diametrically different from what is the prescriptions, correct? But with my experience, I would say that it is better to have your dignity, have your respect, because your understanding of your right or wrong of a judicial officer will be very subjective. For an example, I am an advocate, right? Having a practice of 2 years. You know, I have lots of energy. I think every case has a lot of injustice and I am a savior of the whole earth, right? So therefore, anything happens, this and that, what is beyond my expectation, I feel that judicial officer is wrong. So therefore, that requires a maturity also to understand that should we really take it there or not. So take my personal note on that. It's your right to overlook it. So keep that in mind. I don't want to say anything because I am on camera. So be careful of exercising it, because you remember one more thing why I am saying that. You know, nothing, it's little philosophical but it will work. Nothing is permanent except change. So today we have this, tomorrow there may be a different law. In fact, the laws keep changing. In fact, when we go to some other areas, we will see that there are a lot of changes also happened here. But what about during this time? What to do? So be cautious. If you feel that I am a passionate person, I love to fight a lot, fine, go for a fight. If you feel no, I don't want to be in the back seat, that is also fine. But if you find it's a mid path, you can do that. But my personal take on this is that this wrong, to say na someone that you are wrong, you need enough information. So we don't have. Our information being limited, data being limited, and jumping into an action, it might land you up with the other provisions. Because I could have understood this is the only provisions in your duty. No, there are many others which are very conflicting in nature. So therefore, yes, you understand what I wanted you to say but didn't say. So let us go to second one. An advocate shall maintain towards the courts a respectful attitude. Let me. I just remember one thing, because I just took my note. I forgot to say that. I just wrote on that portion. I'm saying about the other provision. I wrote there safety valve. That's a very, I think, good word I can use. So you can use it as a safety valve, right? When is a do or die situations, only for that, not otherwise. So advocate shall maintain towards the courts a respectful attitude, bearing in mind that the dignity of the judicial office is essential for the survival of a free community. Now, this has a very interesting thing. Like, why do I have to act in my chamber when I'm having a discussion with my client about the dignity of these professions and the judiciary? Why? Because you are living where? In the same tree. So don't cut that tree. Let us say when you are in a conversation with a client, don't say, because you are not on camera like what I am now. You can afford to say many things to your client. Sometimes what happens, it is very easy to say. Your case is difficult. You can say, look, I know that that judge. So, and then you say dash, 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 dash. Correct? Please don't do that. Even if it may be true in your subjective morality. Why? Because, if people do not respect judiciary, they will not respect you also. And judiciary being the last resort, when everything is not there, this is the only place everyone goes. Even the person who is going to kill the judiciary, for him also or her also, it is the judiciary ultimately is the real savior. So remember that. Again, why do I need it? I need to insulate myself with this because it's me. The moment you think it's me there only, not in an ego sense, but in a extended sense, then you will definitely not say anything which is not good for the judiciary. Correct? You talk about on merit, fine. In court, though, of course, you won't be able to say because of fear, right? I'm saying even with clients in your private capacity, don't talk those things because ultimately your clients will save someone else, and ultimately you somehow create your situations in not a very respectful manner. So I just wanted to think about that, why? Otherwise all of you understand this. If any one of you wants to add anything on this, please do, welcome. Anyone can, if you think that anything I want to share here also for my consumptions, your friends' consumptions, please feel free, right? You don't have to think now if it comes spontaneously. You don't have to force for it, right? If you feel that, oh, this thing is coming to mind, why not share? Feel free. Now, and you see one word I just missed. The last two words, the free community. So this is free community in a sense. You have a lot of independence, that sense. Of course, lot of independence also doesn't give B right to appear based on his heart. There was some level of, you have to control yourself because of your do's and don'ts. But when you compare, you find that there's a lot of independence you have. So that's where the free community. Now let us move to rule 3. An advocate shall not influence the decision of a court. Let us pause. We can through our persuasion in court. Right? So therefore, advocate is supposed to influence or persuade, but this is in a different process. By any illegal or improper means. Do I have to say anything? Right. Yes. Private, but the next part, I think there is a thing you need to know because it's a very difficult to tackle with. Private communications with a judge relating to a pending case are forbidden. Let me give you an example. Look, it's fine for you not to talk. If the judge talks, how do you handle with that? I won't name anybody's, but it's a very difficult situation because you can have a conversation with your colleagues, not with your boss. I'm saying metaphorical boss. If the judge gives you a call and wants to know something this and that about the matter pending, how do you tackle with that situation? I think what you do, you think, so your survival, it's in your hand, correct? But I can tell you what I have done. You can say very politely, you can say, sir, this matter is there. You don't take the responsibility of your own decision, right? What you do is, sir, actually there is a prescribed statutes. There are certain do's and don'ts are there. So, I think it would be better for me not to talk about that. Because what I'm telling you, as a senior advocate, many occasions say someone gives me a call and says to appear in a matter, correct? And many of them from this judiciary, this institution itself, it becomes very difficult for me because when I say that I cannot appear, because let the advocate record, call me. First, so they think, oh, what a fancy. He thinks himself as a lawyer, so arrogant. Then only savior thing is that you have to say there is a code of ethics. If I don't follow that, it would be a misconduct and I'll have my license. I want to practice. I don't know anything else to do. So therefore, please, you have to tackle that situations. But At the young stage, you may not face it, but some stage you will definitely. And remember one thing, when you actually very politely remind, you are also adding your that respect towards profession also. Because then, if you were swayed with the whatever conversation was going on there with the pending matter, with the judge, maybe it could have been you were thinking, okay, I could be in the good book, but no, because it is you won't feel good also if you are a kind of person who feels that even otherwise, let us say you don't know about any of these do's and don'ts, you won't feel good about that. So therefore you can bank on. You don't have to say that, sir, I don't like it, because then though it's you versus the other person. But you can say it's not about my liking, it's about I can't, because there is a prescriptions, and if I do, there can be a misconduct. So once you say that, thereafter if you are pushed, I remember in one of the occasions I had to write a letter in a legal aid, the cases comes, so I had to write a letter giving reference to sections of, there are 2 classes of advocates and these are the do's and don'ts. I can't appear because then it would be a misconduct unless there is an advocate record. So yeah, I will find that most of your colleagues are actually not aware of the do's and don'ts. They might be following many of them with their common understanding of what is good and bad. Let us then go to 4. An advocate shall use his best efforts to restrain and prevent his client from resorting to sharp or unfair practices, or from doing anything in relation to the court, opposing counsel, or parties which the advocate himself ought not to do. Let us put a pause here. What is sharp practice? Let me give you an example. It's a true example. Since I am not naming, I can say that. Say a case is going on. My other side says that I will be giving you the paper books, paper books, and outside the court. The court says, do I have to record it? I said, no, not necessarily, because he is the learned advocate. He says that is enough. So court adjourns the matter. There is no recording. Incidentally, the matter is not taken up for the next months, and he doesn't give you the paper books. And the law, as per the High Court rules, say I am supposed to get the paper book from the department. Correct? Usual law, but that is not followed. It is served by the other side. After 6 months, when the matter comes up, I say the copy has not been given to me, you told me. Then he says, where is the order? This is, look, he is not wrong. You have nothing to prove. But this is a sharp practice. To my understanding, this is not good. There are many examples. I think this is a true example that happened. That's what I'm saying. I think many of you might also face that. That your colleagues say something and they take advantage of absence of some kind of evidence to that effect. No, absence of evidence, so we are supposed to take advantage. But in a merit of a matter, not regarding the conduct of us. And next part, an advocate shall refuse to represent the client who persists in such improper conduct. Now, this is a very, very helpful thing for us in a sense. You find some of the clients, they will come and they will tell you, please say A, B, C, D. And according to you, you find, no, I can't say D because it would be suicidal. Because you have your legal knowledge, he does understand, and he tries to somehow persuade you. Now there this in do's and don'ts say that and he might also take some illegal method, etc. You can clearly take a stand. No means no. So therefore this cannot be done. But there also it's very easy to say, but there is no other way. He shall not consider himself, this is the extension of that. He shall not consider himself a mere mouthpiece of the client. Exactly that I said. Because your client would want that every part of his story, when he got up early in the morning, when he had a toothbrush, when he had his breakfast, everything has to be said to the court. But you know that you get only 5 minutes, 10 minutes or some more. So you have to selectively say, no, breakfast is the only thing that I would be saying. I don't have to say because it is irrelevant. So your client might say, look, what are you doing? My instruction was to start from getting up early morning. So why have you missed that portion? You can say, look, I am not your mouthpiece. I as a lawyer, I have to take my own call. But that saying will depend at where you are, what standing you are. Usually in the beginning of the practice, it is very difficult to take the, that pressure of the client because you think I may lose the client. If I say this much, the client, okay, very good, I am going to other person. He will start not only from when I got up in the morning, when I had a sleeping on the last night. So, yeah, but still, it's your choice whether what kind of advocate you want to be, whether you want to become an advocate like B in his competency part or an A. He shall not consider himself a mere mouthpiece of client and shall exercise his own judgment in the use of restrained language in correspondence, avoiding scurrilous attacks, pleadings, using intemperate language during arguments in court. I think this part, do I have to explain, or this is basically same thing can be said in different ways. You don't need, you shouldn't attack a judge. That's the worst thing that you can do as an advocate. Forget about that, the worst thing. There is a prescriptions, there is a statutory do's and don'ts. You are not supposed to attack the judge. You can say the same thing in a different manner. You can get it very subdued, differently. So follow that. 5. We started about that. 5, dress part. An advocate shall appear in court at all times only in the prescribed dress, and his appearance shall always be presentable. Presentable part, I can vividly see, I can see, I hope some of you also have some experience of absolutely shabby way they are presenting themselves. I hope you're giving your answer by your smile. Yeah. And I know some of my colleagues, I'm seeing it for last 15-20 years, then juniors, they will not change. But neither their professional growth will change. So therefore one should be presentable. It's not only in court, wherever. If you are presentable, whenever you go outside your home, so you should be presentable. Now in case of court, there is a prescribed dress code. So you follow that dress code and be presentable, it helps a lot. And in this case, you don't have to apply your mind for that because that's a requirement. You are not supposed to appear minus gown or a very colorful dress in court. You shouldn't. 6. An advocate shall not enter appearance, act, plead or practice in any way before a court, tribunal, authority mentioned in 30 of the Act, if the sole or any member thereof is related to advocate as father. Just take note of these are the restrictions, because many of us know that I shouldn't, but do not know which are the specific restrictions. Like if my father is a judge, I shouldn't appear before my father. Father, grandfather, son, grandson, uncle, brother, nephew, first cousin, husband, wife, mother, daughter, sister, aunt, niece, father-in-law, mother-in-law, son-in-law, brother-in-law, daughter-in-law or sister-in-law. So fundamental thing that a chunk of relatives you are not supposed to appear. I think that is followed. I am not aware. That is follow. The people, they don't appear that. Let us 7. 7. In fact, just yesterday, you have the live law. We get the WhatsApp messages, etc. I was seeing the live law, I think in Maharashtra. One of the advocates got suspended because of wearing gown in public. Did you know this? You can't wear gown, in band, you cannot wear. Now, thing is that many of these prescriptions were not looked into seriously. But nowadays, when I go to the judgments, but you will see the Supreme Court is saying very strictly. And the bar councils are also, they are becoming proactive on that. So for an example, say you go for any demonstrations, correct? Or let me give an example. Say, at your home, say someone has come for taking an interview, right? So let's say from television, etc. But the journalist says, look, sir, you have to look like an advocate, so you have to wear band. As if advocates all the time, even when they go to bed, they wear a band or coat, right? So remember, in public, you are not supposed to wear it. Now, I don't know, say you have a tribunal, from High Court to tribunal. You are going. If you go by a public transport, you shouldn't. Now, if you go by your private car, I don't know. In my case, I wear it, right? I'm telling you the truth. My defense could be that it is, the road is public. But if you go to the object sought to be achieved was what? That in public should not see you in that dress that was supposed to be or exclusively for the court. So that little bit of stretching, I think, take your own call. But I have a feeling that in a public places like you are going to court starting from home to say the court itself, say you are wearing wherever you are going with the band, and shouldn't. So an advocate shall not wear bands or gown in public places other than in courts except on such ceremonial occasions. Oh, there is an exceptions. And at such places as the Bar Council of India or the court may prescribe. So there also prescription is necessary, not just, I think it's ceremonial. Now, 8. An advocate shall not appear in or before any court or tribunal on any other authority for or against an organizations or an institution, society or corporations if he is a member of the executive committee of such organization or institution or society or corporation. Executive committee, by whatever name it may be called, shall include any committee or body of persons which for the time being is vested with the general management of the affairs of the organizations or institutions, society or corporations. Now let me just give you a simple example so you will be able to understand it better. Simple, let us say that you are a member of a managing committee of a school. There may be a litigation relating to that school, you cannot appear there. Or you are a director of a company. A litigation relatable to that company, if you are a director, you cannot be advocate. So therefore, I have seen many advocates. Maybe they are not aware of it, so they practice in that way. So, once you know that, it's your choice, as I said. Though legally speaking, it's not a choice. Legally speaking, if you are doing it, you are taking a risk because it is a misconduct. Tomorrow, who knows, you may have a very good friend of yours, good friend, who might make a complaint and you may face the music there. So therefore, it's better to follow it. 9 is relatable. Like, an advocate should not act or plead in any manner in which he is himself pecuniarily interested. So, if the judgment is going to fetch you money, not as a fee, then that's a big no-no. Like you have any financial interest in a matter, then of course you cannot be advocate. You cannot be an advocate in that manner. So there are some examples given. So these were the duty to court, correct? Now come to duty to client, the real difficult part. So by the way, you can read now. Why don't any one of you read that? Then we explain, so that your involvement will be there a little more also. You start from 11.
Number 11.
Yes.
An advocate is bound to accept any bribe in the courts or tribunal or before any other authority in or before which he proposes to practice at a fee consistent with his standing at the bar and the nature of the case. Special circumstances may justify his refusal to accept a particular bribe.
Look, this is something very dangerous. Look at that way, unless you really find out some. So, okay, you don't have to read, I am explaining you in a very simple way. It simply says that if a client is willing to pay your fee, you are bound to accept the brief. Remember it, you can't say no. I hope, were you aware of it? That you thought I belong to a free community, independent, I can say no, right? There is a different prescriptions, you see. So if you look at the subjective morality also, why can't I say no? Of course I can say no because I am not taking your money, it's my life. But when we go to other, you will see that there are, I shouldn't say ways and means, I would say you have to take a harmonious call. For an example, if you are too busy a lawyer, correct? And you know that client, you may not be able to appear there because of the fact you will be engaged in another court. And you are for sure that client is going to make a complaint if you are not there in that court. So what do? So you have to say that I don't have time, but the time point is not part of the prescription. Prescription says that only part if he is willing to pay that your fee. That's all. Now, the special circumstances may justify his refusal to accept a particular belief. Now, special circumstances. So, that's a cue. That's a cue. If you find out a special circumstances. So, in fact, I was thinking of one of my experiences where I would not name anything. It was not a very good experiences of me. I can just share without naming anyone and without going in toto of the matter. Just a rough view, so that there was a matter where very old ladies, she wanted me to appear. Now, she could not afford my fee, and some part of that B, I thought, okay, I will be appearing, because his case was that it was basically a dismissed case, a review sort of. When I appeared in the review, I took a stand. Some part of the order was good, some part of the order, I thought that she should not insist. After that favorable order is passed, according to me favorable, now she said, how could you concede on one point? You see, there is a difficult part. Because you know that if you had asked something more, you would have lost. But now you are in a vulnerable situation. Then it's, by this, that, at some point you have to say, sorry, I can't appear further, right? It took about 6 months for that lady to realize that that was the best decision. And what I did was right. But I said no to that. Thereafter she came to my chamber. She said, sir, you have to appear. Actually, I had no difficulty to appear, but because of the nature, you can't when someone tells you that you have to say A to Z. It's, you know what to say. She said, no, I will not leave the chamber unless you say yes to that. Literally. All my chamber juniors were there. I think it was about 2 hours. literally 2 hours. I mean, she said, unless you say, first 1 hour she was persuading that. Because then I realized it was more of a mental faculty thing. You know, some people like, you know now, there are, look, once you experience the beauty of fire, you know how much it can burn you, right? And once you know that it is going to burn me like anything, so you have to take a stand on that. Sometimes in life, also in our professions, your choice would be not between the good and the bad. It will be a bad and the lesser bad. Because really, it's not that you have no choice of being good. I know that some kind of, you know, these disturbances I will be facing, but at least it will save me from some others. When you are going to give your full heart for your client, you don't expect that your client who doesn't have any knowledge on that would criticize you without say any iota of what the person is saying, correct? You have to maintain your dignity, self-respect. So therefore in those situations, I think you have to somehow separate yourself. But here the prescription is different, you can't refuse. Okay, so now it's your call to have your own interpretations of special circumstances. Just keep that in your mind, that this is the provisions. You see, you may have to face with that, no, you are bound to appear. So you may say that this is the special circumstances. On coming Monday, I actually have a different matter, totally engaged. I will not be able to give any time. Correct? I hope you understand that assumptions that I have made of Monday matter. Okay, then 12. An advocate shall not ordinarily withdraw from engagements. By the way, this is very important, correct? I think all of you will come across this. Withdraw from engagements. Okay, sorry. Now you read, because that would be a good thing. Why should I read all the time?
An advocate shall not ordinarily withdraw from engagements once accepted without sufficient cause and unless reasonable and sufficient notice is given to the client. Upon his withdrawal from a case, he shall refund such part of the fee as he has not been earned.
Now let us make it simple. Do not just put a full stop by saying, no, I won't appear. If you do that, your situation may be very vulnerable. If for any decisions, if you feel that you are not going to appear for any reason, sufficient or special circumstance, whatever it is, give a letter, give a notice saying that you will not be able to appear. If that is absent, you may face difficulty. I mean, that, remember, face difficulty means it could be a huge difficulty, and there are examples that there are some clients, they will not leave you. They will pursue it to the highest. I have appeared for some of the advocates, and I know those advocates, they had absolutely no flaw, no, nothing they have violated. But they were pursuing and pursuing, and if they start pursuing, you don't like as a lawyer to become a litigant. You don't like that. I remember just the last week I was appearing for one of the colleagues of me. It was a case where one of my colleagues was arrested by police. He was actually giving a television interview, and he said a little bit of things about something. It involved the chief minister. So he was picked up at night, and he was taken to custody. So I was, he got the bail, but I was moving before the High Court because that section 41A was, that was not complied with, and there are some other provisions also, and some judgments of Supreme Court in Anesh Kumar, Rini Johar, whatever. So yes, matter is still pending. I'm giving example for a different reason. Now, the colleague of me, he was there without the band because he was there, he was the litigant, the ex versus the state of West Bengal, etc. Then I was telling him that, look, you don't like, as a lawyer inside the courtroom, not wearing your coat and gown, it has a very psychological negative feeling you have. So, why I've given this example? That as a lawyer, you don't want to be a litigant. So, but if you make yourself vulnerable for some reasons, then a complaint can be there before the bar council, and there it's not your choice. You will have to be a litigant. You have to go to another lawyer, or you have to do it yourself, which is not very, very, very nice feelings altogether. So that's yes. So it's your turn. 13, I think.
An advocate should not accept a brief or appear in a case in which he has reason to believe that he will be a witness, and if being engaged in a case, it becomes apparent that he is a witness on a material question of facts. He should not continue to appear as an advocate if he can retire without jeopardizing his client's interest.
So, do I have to explain this, or it is quite simple. Read it once more, in case you find any difficulty. Look, basically it says this, that if you are a part of that subject matter of the litigation, in some earlier provisions you have said that, here it is relatable to witness, then you cannot be an advocate. It is as simple as that. So, yes, now you, next one. Let me see.
14, sir.
Yes.
An advocate shall, at the
Let me sit little,
Okay,
because
sir.
standing for, yes.
An advocate shall, at the commencement of his engagement and during the continuance thereof, make all such full and frank disclosures to his client relating to his connection with the parties and any interest in or about the controversy as are likely to affect his client's judgment in entire engaging him or continuing the engagement.
So, it's basically transparency, right? Look, on the other side happens to be my cousin. You make it clear. Are you still willing to engage me? The other side happens to be the advocate with whom once upon a time I had a marriage. We are no more spouse. You make it very clear. Thereafter, if he chooses you, well, it's simply that it should not be a surprising factor. Some connection somewhere, you just say that. So, it's nothing more than that. Yes, you. This is 15.
Number 15. It shall be a duty of an advocate fearlessly to uphold the interest of his client by all fair and honorable means without regard to any unpleasant consequences to himself or any other. He shall defend a person accused of a crime regardless of his personal opinion as to the guilt of the accused, bearing in mind that his loyalty is to the law, which requires no man should be convicted without adequate evidence.
You see, there are two parts. Second part helps you from your psychological problem sometimes. Remember, I think sometimes after all of us, we are human beings, right? So we have our do's and don'ts, nothing to do with this. Sometimes we don't like to do certain things, which may be part of the profession also. But once you know that your do's and don'ts which are prescribed, that lets you appear for anyone. Correct? Because everyone has a right. Everyone has a right. No matter, he is known to be as a murderer, he is known to be a rapist, he is known to be, a terrorist, whatever it is. Like you might see that, in fact, there has been some resolutions of some bar council, bar association or some places that we will never appear for a particular person because he has done such a gruesome thing. In fact, there was an occasion where the matter went to Supreme Court, and Supreme Court said, you can't have this kind of, resolution. So what I'm saying is that as an advocate, we need to have a very attitude that we are going to uphold law. Correct? In some situations there may be some conflict with the morality. I don't disagree with that. But you can look at, okay, let me explain. I will be able to explain better when I stand. Just after a little bit of tea, I will do that. Because this part, you will come across sometimes in life, that you will see that, is it good I'm appearing for a person who has done such a heinous crime? Or is it good, these corrupt people, corrupt means quote and unquote corrupt people. Now, what should you do? Of course, you have a choice of saying yes or no, depending upon, that spatial circumstances. But I'm saying you can also address it for your internal sake, so that you don't also otherwise suffer because of that situation. Look, any one of you has got any personal experience like that? You feel, look, he has done something so wrong, I shouldn't appear. I think it's a very common thing that we face it now. And look, it's very easy. I'm not going to judge. I'm just trying to have a conversation. So I would like to also have a little bit of your opinions on that also. We have our own prejudices, right? We look at in our own way how the world should be, who are good and who are bad, right? Let us assume that someone comes to you seeking your professional help who falls within your category of super bad, right? How do you deal with that? Now say you accept the brief, then you may think, should I actually appear? Then what I'm doing? Am I doing against the society? In that case, of course, there is a point of thinking, from a moral point of view, that's as a human being you will do that, but otherwise also, look at the, this particular provisions which helps you. Look, once you are guided, you have entered into profession, correct? So therefore, these rules are there for you. These are the do's and don'ts. Now these do's and don'ts, now there are many others which are really, you are not liking it because it is taking away some part of your freedom. You are bound to follow that. So here also, there may be some situations which may not be in sync, in conformity with your sense of morality. But that's the prescriptions provided in the rule. Therefore, you can think that professionally, what I am doing, it is absolutely okay. Why? Because no one knows. I gave the example of that microscope and a minus microscope. Let us say the people with the microscope, they are saying that there are thousands and millions of the bacteria in this room. And the other half would be saying, no, they are full. Where are those? So therefore, every time we make a judgment based of our limited informations, limited tools. So therefore, the benefit of doubt, you can look at that way. You can give a benefit of doubt. Maybe the person was on the front page of the newspaper as a corrupt person, bad person's murderer. But that may not be the end of it. And you are not saying he is a good person or a bad person. You are saying that if there is a law, I mean there is, if there is a provisions which is to be applied, I would ensure that is applied to him. If that application lets him free, he will be free. If that application lets him be in jail, he will be jail. But the whole process would be there. There is nothing wrong, I am saying. Nothing wrong in that sense, because there is, no one knows what is the truth. It's very subjective. It is very based on facts and figures. Little bit of change of facts and figures, your truth will be totally different. Take a simple example. Stealing is bad, right? Let us assume that you have not eaten food for the 3 days. You have stolen. Now if I give you a lecture on that, don't steal food. So question is, what will you, how will you respond? Tell me. It's difficult to respond.
Very much.
Right? So therefore, the definitions of morality, definitions of good and bad requires a context. The context is you are in a so-called comfortable situations. The moment that context is changed, things can change. As I said, that each one of us has the potentiality of become excellent and also opposite. So therefore, you can look at it in this way. If you are ever troubled with these situations, am I doing the right thing? You just think this way. What you are doing? You are appearing from someone who may be on the front page, who happens to be said to be as a bad person. But you are not here to give him a stamp as a good or a bad. You are here to tell him, look, whatever you have done, for that there is a process, for that there is a law, there are rules and regulations. Therefore, to the best of my knowledge, I would be trying to see those are applied to you. That's all. The moment you do that, two things I think you need to do a little bit, and this is not really legal, but from my experience I am saying, you have to attach yourself with this study part of it, research part of it, correct? And you have to detach yourself from every other part of it. So it is little philosophical, that simultaneous you are attached and detached, but it will work. Detached in the sense that you are not really caring about what is going to be the end result of it. For an example, say we are having in this program, correct? I am saying something, you are also saying little bit of things, there is some kind of conversation is going on, so that we are hoping that some kind of, what is that, sensitizations, vaccinations we can call it, right? In the vaccines, so what happens, that you get yourself immunized, your antibody works against the, so that way whether we can get ourselves sensitized in this conversation, etc. So think over it, just think over it, that once you are attached with your what you are doing at, fine, but once you are detached with the result part of it, say you are totally prepared with the matter, you are there in court, you are arguing a matter, and very well it will happen that whatever you thought, it has happened totally different. It's a very common experience, it happens, correct? So if you are detached to a sense, it's not a switch on and switch off, it's a practice, what you are doing. If you practice on that, then I feel that neither you face too much of that, the complex problems internally, and also you don't make ourselves vulnerable. This is more on that. Yes, what was the next? 60. Yes? See?
An advocate appearing for the prosecution of a criminal trial shall so conduct the prosecution that it does not lead to conviction of the innocent.
Just pause for a moment. Look, attached, right? That you should do your work. Simple. Because it tells you what? It tells you try your level best. Simply, nothing else. Yes, carry on.
the suppression of material capable of establishing the innocence of the accused shall be scrupulously avoided.
You see, it's said in reverse. In a sense, look at the suppression of material capable of establishing the innocence. So, not the guilty part is talking about, it's silent on that. So you can make an inference. It talks about that your every effort should be so that I can make him innocent. This part of the rule could have said also otherwise, but it is silent on that. I am not going to take any side of that. All I am trying to say, there is a noticeable silence on that part. You can call it detachment. I don't need to know about the result part of it. But my effort, there is a thrust by the rule that I shall put my heart into it, I shall try my level best so that that conviction doesn't happen. Yes. Yes.
An advocate shall not directly or indirectly commit a breach of the obligation imposed by Section 126 of the Indian Evidence Act.
Basically, these professional communications, like, privileged communications. Say someone divulges, you can't really, take advantage of that situations. You can't. I think that part, all of us, we are aware of that. So many things are said. But those are professionally, someone has come to a chamber and divulged those, nothing to do with, you are supposed to give the correct legal advice on that. You are not the judge there. Yes.
Number 18, an advocate shall not at any time be a party to fomenting of litigation.
This fomenting is basically instigation, So it basically says that, there are, I don't know about this code. There are some nature of cases which happens in bulk. I remember in our times means still I am alive and okay. So interview matters, those used to happen like, like masses kind of, hundreds of matters. I am aware of that, some of the colleagues and some of the persons. Fomenting is basically, you don't instigate for litigation, correct? You don't fuel a litigation. You don't somehow create litigation, correct? It may be good to you, that's a different chapter altogether. In some cases it is not good to you. So your role is to be, if someone comes to you, you help him out with your whatever knowledge you have. The knowledge of A or the knowledge of B, whatever. Or maybe a knowledge of, we can say, the B plus. Plus is the ethical part. Okay, whatever it is. But in whatever sense it is, you have to be very careful of this. Yes. Next.
19.
Yes.
An advocate shall not act on the instruction of any person other than his client or his authorized agent.
Yes, this part remember, particularly you want to withdraw a case. Say someone tells that do go for a non-prosecutions. Please ensure that you have an instructions for non-prosecution. Do not trust, because it's your appearance, you go and withdraw the case. Tomorrow if the client says, who has authorized you to do that? There are cases where he's lost his license for that. So just get yourself vaccinated on this count. That no matter that, when you see that the client is there, you ask his signature, his letter, or his authorized agent. Better his, that's the best way. Or her. Yes. Next. Oh, you have just said. You can. I think we have more number of rules than the number of persons. So no issue. We can continue.
An advocate shall stipulate for a fee contingent or the result of litigation, or agree to share the proceeds thereof.
You see, the best part of it, what you have not said.
Shall not.
Just remember that. I think that's the best way to focus it that way. Take the example, if I tell you now, don't look at anything that is green. The first your mind will do is look at the green. Right? So I think that's the best way that you have explained it. That you have not said the not, and actually we'll remember it more. Yes. So this part I have to explain you, because this is a very common phenomenon, I believe. Maybe in the motor vehicles, maybe in many other matters. Let me read, right? With not this time. An advocate shall not stipulate for a fee contingent on the results of litigation or agree to share the proceeds thereof. Correct? Let me make it simple. In fact, last night, because for this program I had to read little. So last night I got a lot of time in the hotel, so I was reading, I got a judgment. So I will tell you, where there was a advocate, senior advocate I believe, I will check it maybe, who said that if I am successful in the matter and if this amount comes, 50% would be my fee. Right? And he did a great thing. He made an agreement. He suffered the punishment up to Supreme Court with a long, paragraph saying about this is absolutely unethical. Remember one thing, that there are two sides. Let us look at it from both sides, correct? From the opposite sides and the way what is prescribed. Let's just say someone comes up to you that he is actually poor, right? He is not able to pay you money. He says that when I get the money, which is a very common thing now, we can't ignore. No matter the law doesn't take note of in sometimes the reality, let us have some reality check. He says that, every time I'm saying he says, she says that, both are. So that once or if I get successful in the matter, I will give you the fee and that's a percentage of that. This is a big no-no, remember it. Because a lot of advocates, they have got punishment on that. Now maybe here the say state bar councils may not take it because that complaint is not there. Tomorrow you do not know. You do not know. Who knows? Even this video, I believe that they also upload on YouTube, right? So who knows? If, otherwise, a client who was not even aware of, now he might think, now I am sensitized. How to deal with the lawyer? He might make a complaint on that. Correct? It might go both ways. So therefore, don't make yourself vulnerable by that way. No matter your heart is like bee's heart, be aware of, if I do that, I may face with the consequence of spending more number of days at home only. I mean, at home means your home, not to jail, right? Not in the court. So, it's a very big no-no. I'm saying little more on that because it's a very common phenomena. You have got nothing to do with the result of a case, subject matter of a matter, correct? Your fee should be X, Y, or X plus Y plus, or X minus Y plus, right? Whatever it is, depending upon whatever you think to be the correct. Now, whether it is a matter involving whatever, 1,000 crores or 10 rupee, you should not think and decide your fee on that. There is one ad I can say, I actually follow that, even without knowing this. Because genuinely speaking, I did not read all these do's and don'ts also so carefully. I believe none of you has also read it. Because we don't require to. Now, say there are sometimes what happens that cases come, say there is one petitioner, there can be more number of petitioners. So you can have your own fee structure on the basis of what is your appearance, not on the basis of how many clients are there and multiply with that. That is actually big no-no, remember. That's not the prescriptions. That's within the category of a big no. So if you do that, it's your option that you are exercising towards, as I said, some number of days at home. Yes, so
An advocate shall not directly or
there was also another, option of not. You this time carry on.
An advocate shall not directly or indirectly bid for a purchase either in his own 21. An advocate shall not buy or traffic in or stipulate for or agree to receive any shares or interest in any actionable claim. Nothing in this rule shall apply to stock, share and debenture of government securities or to any instrument which are for the time being by a law or custom negotiable or to any mercantile documents of title of goods.
Fine. You see, this is basically the core was in the previous one. That say there is an actionable claim, something like that. If this litigation is done, the landlord will get the money, right? The rent amount. So don't make your fee on that. It was basic core. The point was in the earlier one. So you have got no role to play so far as the whatever your client is getting. Your fee should be your fee, separate, nothing to do with the actionable claim also. Yes. 22.
And
I think she began with 22.
an advocate shall not
Well, just some lighter note actually, because we are going through a very dry subject, correct? Law itself is often dry, and the ethics of that though more than that.
An advocate shall not directly or indirectly bid for or purchase either in his own name or in any other name, for his own benefit, for the benefit of any other person, any property sold in the execution of a decree or ordered in any suit, appeal or other proceeding in which he was in any way professionally engaged. This provision, however, does not prevent an advocate from bidding for or purchasing for his client any property which his client may himself legally bid for or purchase, provided the advocate is expressly authorized in writing in this behalf.
So, by the way, how much time we have? Half an hour.
Half an hour.
So all of you are very hungry now. Okay. So I will compress little bit of, correct? Because there are some sections on judgments part that we need to know also. There is a big vaccination part is there. So the core part of it is the same thing. Instead of going into all bits and there, just understand your role as an advocate. You must detach yourself with the result of your advocacy. Simple. Whether what kind of benefit your client would be getting, you have no role. Right? Yes, now.
22A, an advocate shall not
You
directly...
see, is it for the first time we are having something with an alphabet also, 22A? Because for the first time,
Yes, yes.
you got what
Yes.
what I didn't say? Representing the entire gender. As far as that side is concerned. Yes.
An advocate shall not directly or indirectly bid in court, auction or acquire by way of sale, gift, exchange or any other mode of transfer either in his own name or in any other name.
You see, this is the same thing basically, correct? because of some paucity of time we are going little fast. So 22A is under the same category. Don't get yourself involved with the litigation's results that way. You should do 23 also because otherwise the balance would be disturbed.
An advocate shall not adjust fee payable to him by his client against his own personal liability.
Similar thing. Again, that detached yourself with what liability, your personal things. Let there be a hat trick.
An advocate shall not do anything whereby he abuses or takes advantages of confidence reposed in him by his client.
Just connect with there is a similar provisions we just read, that communications. Someone has really became totally vulnerable and that happens in your chamber said, so don't take advantage of that. I remember many years before I had to do a case. There was a lady who went to the for counseling session, and there though you happen to be absolutely vulnerable because that's the process. Now that gentleman, the doctor, who according to her, try to take some advantage on that count because now he has lot of information which only you know or that person knows, and one case was there on that basis. So remember, whatever the client says and you hear, you are not supposed to even share with anybody, not even with your spouse or anybody else. Correct? But minus the name as a matter of subject for discussions, that is permissible. That is not a different. But without that, please take care of that. Yes, let us.
25. An advocate should keep accounts of the client's money entrusted to him, and the account should show.
You see, it did not read because it is basically more of the simple things. Of course, it's that you must take care of the money given by your client for some accounts. Say A, B, C. A for expenses, B for fee, etc. You must maintain accounts in that way. There is another provision for that. So this is more on that. You can read once more. Another. One more, I said, not this one.
26. Where monies are received from or on account of a client, the entries in the account.
What I said, basically. So let us not read that, na? You understand. That say the client has given some money, you separate, this is for the photocopying, what you call as a xeroxing, whatever. Now, this is for the court proceedings, some these, that, and your fees, etc. Don't mix it up. Yes, it presupposes that there are so many clients. Yes, carry on.
27. Where any amount is received or given to him on behalf of his client, the fact of such receipt must be intimated to the client as early as possible.
So I'm going now quickly, right? Because of paucity of time and because of the fact that all of us are getting hungry and hungry. So 28, after termination of the proceeding, the advocate shall be at liberty to appropriate. This is basically the same thing. Just read yourself later on if you ever find any chance to go through this dry subject, right? But otherwise, once you know that I am supposed to keep every account separately when I have lot of clients, remember it. 29 is basically whatever is left over, you are supposed to return on that. I am not reading it entirely. 30 is basically the client's copy. 31 that you cannot divert it to as a loan. Now instead of all individuals, if you look at what is the broad understanding is your professional thing is completely detached from the results. Once you understand that, once you are sensitized, I think rest it's okay. I'm not going through this explanation. Let us say the duty to opponent. This is something. You have some duty to opponents also. One is that shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by an advocate except through that advocate. So remember this part. Let us assume you are fighting a matter, correct? Let us say A versus B. Not A versus B because they are not the litigant. In the fight as an advocate. So there the A cannot go for any negotiation with the B's client. Simple. You can go to B, no problem. The advocate and another advocate, they can negotiate. But without the consent of your other side's advocate, don't go to the client. Just because your client happens to be your neighbor, you live in the same apartment, you can't do that. You can tell him, I could have done it otherwise, but I can't do because of the do's and don'ts. I will suffer. If I lose my license, you are not going to restore it back. Then, you see, this is something very, very honorable, that my paper book thing will comes here. Read that, or I am reading it. An advocate shall do his best to carry out all legitimate promises. That I will give you the paper book. Made to the opposite party, even though not reduced to writing, or enforceable under the rules of the court. Exactly, it fits into that example. When you say to something to your other side, it's good that you try to keep it. But look, don't take an extreme view of the matter. Your other side, maybe you never know. So you have to be careful about that. Who is your other side? So on that basis, you should give that kind of promise. If you find you have an excellent other side, be careful about any promising thing. Now, duty to colleagues. This is something very important. Very important, remember. Let me read. An advocate shall not solicit work. You go to another advocate, go to a place, go to bar association, please give me work. Never. That is soliciting work. Or advertise. This is another big area. Though because of the change of time, there has been little change, which is not there in this book. Now, you can't advertise, correct, but you can have your website. And there, I think there are 5 informations. Your name, your enrollment number, etc., etc. Those can be given. So, shall not solicit work, advertise either directly or indirectly by circulars, advertisement, touts, personal communications, interviews, not warranted by personal relations, furnishing or inspiring newspaper comments, producing his photographs to be published in the connections with cases in which he has been engaged or concerned. I hope this doesn't fall in that category because they would be uploading. Okay, this was a lighter note. His signboard or nameplate should be reasonable size. Remember, don't make a competition with a signboard of a businessman, right? Or a trade. He has given, 10 by 10. It might have to be better, more than that. I'm an advocate. I belong to, higher nobility of profession. So my signboard has to be, more than that. Remember, no. His signboard or nameplate should be reasonable size. The signboard or nameplate or stationery should not indicate that he is or has been associated with any person, the Chamber Junior of Solicitor General, or son of former judge, please, or organizations or with any particular cause or matter of that he specializes in, or organizations or with any particular cause or matter or that he specializes in. I'm expert in narcotics matter. I'm expert in electricity. You can say that. You can say, I can, just simple things that if you think about, make a connections, if you go for a advertising kind of thing, if you go for a soliciting work, you are actually not going towards self-respect. If you beg for cases, other persons will not give you respect. Understand these things. So you have to learn somehow to leave some number of days without whatever, money, etc. And you have to focus. There are ways. You can take these examples. There are many advocates who are successful and who are also following that. If they can do that, why can't I? Because this is hugely violated by many advocates. And I find whenever there is a matter which has some controversy, anything, first thing they do, go for a television bite, etc., etc. Now this is directly not related, it's a personal choice, but I have a feeling that if anything that takes you very up, suddenly it will put you down. So it is better to be detached and focus on your professions. If you are good at your professions, you will definitely get all the respect, even if you don't want it. I mean, yeah, it's a cliche to say there is no shortcut, but I don't have any other thing to say. 37 is also that not permit his professional service or his name to be used in aid for the make a possible unauthorized practice of law. Of course, you don't allow your name to be used by, say, a trader, that etc. An advocate shall not accept a fee less than the fee taxable under the rules when the client is able to pay the same. I don't get it. What do they mean by fee taxable under the rule? I don't find there is a tax part is a different thing. Let us put it in this way, that if the client is able to pay the same, please allow him to have that, good experience. So 39 has some amendment which is probably when this I have to say since I don't use any paper format, so therefore the book has to be bought, it has to be torn and then scanned. So the amendment was not there in this Bare Act. So I will tell the amendment to you, but here an advocate shall not enter appearance in any case in which there is already a vakalat, 39. We began with AB. Let me read that. An advocate shall not enter appearance in any case in which there is already a vakalat. Okay, just a second. Or memo of appearance filed by an advocate engaged for a party except with his consent. In case such consent is not produced, he shall apply to the court stating reasons why the said consent should not be produced, and he shall appear only after obtaining the permissions. So I think this example we began with, that no matter how soft heart you have, no matter you feel that you are going for a better cause, if in a matter another advocate is there and his consent is not there, say big no. Even if it's a matter, say your relative or any, say big no. If there is a further thing, you say no, not because of my ego or fancy, but because I may lose my license. That's the thing. So these we cover of the do's and don'ts. Now just few judgments which are few things which are very common phenomena. This part you may take note of the judgments. There are I have given the soft copies to Mr. Others, right? So if you want, you can get all the copies of all the judgments, right? It's a soft copy, so you don't have to take a print of it. And I wish that you never come across that situation, but you can put it in a folder in your drive. In case you face any difficulty, you can look up, because it will cover all the areas. There are 19 judgments, correct? So you can, whether for yourself, I wish not, or for anybody else's. So that will be helpful. Now there is an interesting topic that I need to talk about. Actually, by the time when I come here, so you hear my voice, I mean the mic goes.
Yes, sir.
Okay, no, because I hear, I don't know. So, the Bar Association make a lot of resolutions. I don't know what you call here, not to attend resolutions. Someone has died, correct? So, to mourn, yes, correct? There's a condolence and etc. And there are sometimes they are agreed with some decisions. So, you boycotting, striking, etc. Now, remember this thing very carefully. So this is for serious. No, other things, despite lighter note, it was also serious. That do you have a right to strike or not? Correct? That's the question. I am giving you the direct answer. The lawyer cannot go for striking, boycotting. Let us have further question. Why? Because of the Constitutional Bench judgment comprised of 5 honorable judges, Supreme Court, saying you cannot. Please write down this. This is Y84. I think it was in the first. Oh, this is strike. There must be something like strike. The subject matter must be strike. No, you look the subject first. Correct. This is 2000. Yeah, strike. Correct. Let us see. Was it there or not? Fine. You write it down. 2003, 2 SCC, page 45. This is Captain Harish Uppal. You can take the couple of paragraphs of that. It's not there, na? If I email now, can you? Oh, leave it because we don't have much. I'm reading, you can hear me clearly, right? I will email him so that you can get that also. The others are there. Maybe that was missed. So, if I read it, it will take more time. Let me tell you, the Supreme Court had the occasions to deal with variety of questions. Do they have a right? The answer was no. And another point was taken by the Bar Council of India that there are resolutions. Supreme Court is saying that the resolutions to that effect of boycott, etc., anyway stopping the court, the best place to keep that resolutions is in the dustbin. That was the judgment. They said such the requisitions should be considered to the place where they belong. Correct? But they could have stopped there. That is the waste paper basket. Even that was said. And you can just take you can write a few paragraphs of that. Paragraph 31, they say you can't give a paragraph 31, you have no right. And remember, this is paragraph 26, where you may have to bear the cost. Remember, if a client becomes aware of it, if you don't appear because of any resolution, the client can ask for cost, ask for damages also. So remember it. But there is only one exception Supreme Court has said. Because there are a lot of points were taken, and the Bar Council of India gave list of things, situations where they should be allowed, because they said it's a fundamental right because of some situations. Supreme Court negated all and ultimately said only in one situations. The language was something like that: for one day, if it is relatable to the independence of the judiciary, number one. Even that case, permission of the Chief Justice of that court, or say in the district level district judge, is necessary prior to go for that. And there also Supreme Court said that in that case, if it is for one day, we can overlook. That's the language. Not that it is deleted. We can simply overlook. All other cases, they say start the proceedings against the concerned lawyer, In fact, now in Calcutta High Court, there are a number of lawyers, they're facing it. Even contempt proceedings can be done against them. The bar councils for suspension of the license, that can be done. Third, the client can ask for that you have not appeared after signing the vakalat, so therefore you have to give him a cost. And he can also say, because you have not appeared, I have lost this, can go for a WDs. So please be aware of that. Get hold of that copy for your safety valve tomorrow. This. And this was also followed to 2017 5 SCC 702 paragraph 27. You can just take a note of that. 2017 5 SCC 702. The representative of all of you, myself not excluded. Okay, so just remember one thing, for a strike or any kind of resolution not to attend, that if there is a difficulty, you have something to depend on. That's a Supreme Court judgment. Even if the Bar Association takes a decision against you for not following their, Supreme Court says by these judgments, you can ignore the decision of the Bar Councils. And if the Bar takes a decision against you, hopefully the Supreme Court following this judgment will be in your savior, right? Because I just want to let you know that now there is a shift, lot of shift. Earlier, things are changing now very fast. Let's say pandemic. How many of you actually were conversant with the this technology, the virtual hearing, etc. But now that's happening in every court. It's happening. It's going so fast. Tomorrow, a lot of AI, the artificial intelligence will also do so many things that we are doing now. So all I'm trying to say that now it can be okay, boycotting, striking, but based on these judgments, there is a shift. So be aware, get yourself vaccinated on this knowledge and be sensitized, so that your colleagues are saying, okay, go and do it, don't do that, because you cannot do that. You may lose your license. Yes? Yes.
Firstly, sorry everyone, but then also there's a question.
Yes.
Is it like in a day-to-day life, I'm first an advocate, then a citizen of India? Which comes first? Because if I'm a citizen of India and if I have a right to strike, then I can opt for this. But if I'm an advocate first, then I have to politely or religiously follow this, because is it just related with the court premises or only the independence of judiciary? What is it? I'm a little confused on this.
It's a good question. Let me ask you a question. Tell me, draw a circle. It just came into my mind that way. Okay, simple circle. No matter how nicely you paint or etc. So, tell me which is the first side of the circle and the second side of the circle. Yes. In life, you can't really, it depends on that moment to moment. When you are at your home, your family may be your first. You are less a citizen, more a family person. When you are in court, maybe you are first a lawyer, first an advocate, correct? When you are to friends, you are maybe less a family person, more a friendly person. It depends. Look, don't take my words word by word. I'm just saying what I'm responding to this very spontaneously, right? I don't think that you can really compartmentalize in that way that, look, I am Mr. A, I am first a citizen and everything only thereafter. You cannot do that. It varies. Of course you are a citizen, but with some limitations. Of course you are an advocate, but with some limitations, restrictions. Now, how you are an advocate? Now look at this different. Are you an advocate because you are a Homo sapiens? No. You are an advocate because you studied law, you got yourself enrolled, correct? So how you got yourself enrolled? Because of the legislations. So therefore you are utilizing the legislations to say you are an advocate, and you are ignoring the same legislations when it comes to strike. Get my point? When you are a person, you are created by an act. Advocate Act, correct? If you are created by that, you are bound by the do's and don'ts of that. And these do's and don'ts are interpreted by the Supreme Court. And their interpretation is that when you go for the strike, remember, strike doesn't mean all strike. Okay, maybe did I clarify that? I think that's the reason of the, no, you can go for strike, of course, you have a right, you have a constitutional right, but not striking, stopping, boycotting the court. It was my mistake. I made it, generalized it. No, of course you can. Why not? Why not? You are every day you are getting a very bad food from your canteen.
Yeah.
So you make a strike, will not eat food from that canteen. You can, no problem. I am saying once you have signed in the Vakalatnama, you cannot say that on coming Monday, in protest of XYZ reasons, I will not appear for him. That's a strike of an advocate. That you cannot do. The other part of your citizen's life, feel free to do that. I was basically reason for generating this question. I should have. So now few more judgments. Just get the judgments and I will give you what is the topic on that, which we have discussed. This is 1955 1 SCR 490. I repeat, 1955 1 SCR 490, and you may write the equivalent citation is AIR 1954 Supreme Court 5, I think it is 57, but still let me check. 557, right. 557. Now, the Supreme Court, this is a case named Mr. G. Here the Supreme Court actually, because after all it will go against the person, that name was not given. So Mr. G versus such and such. It's an interesting case that where he said that agreement of 50% of the recoveries. I was saying that you can't. Here he did and he suffered. You can just write down few paragraphs on fact, paragraph 2, paragraph 11 and 17. And paragraph 18 also. Just 18, have a look of what can happen. Just last portion of paragraph 18. Yes. Just that's all. Suspended for practicing in this court for a period which will expire. In fact, in this case, not only he had an agreement that he will be getting 50% on recovery, but also after suspensions, he also attacked the Chief Justice before the court. So ultimately, that part of you have to be respectful, and this part had a deadly combination. Well, you can move on to next, 1976, 2 SCC 291. This is, just a second. This part is little funny. You can come to paragraph 17. All of you will get some fun before lunch. In some courts, a litigant comes and there is a rush to snatch the litigant, correct? That happens. I mean, here though number of advocates are very less, it's not, I don't have no idea, but some parts it happens that the litigant is somehow, snatched that way. But this advocate is saying, no, he's mine, other is mine, that way. So some kind of commotions, little bit of fight, etc., etc. That practice, just look at the paragraph 17, that part. I have seen that evidence. I have seen Mr. such and such, I am not reading the name, accosting people. I have seen Mr. Such and Such snatching the papers from the hands of the litigating public. So this, I'm not reading the entirety. You can read it yourself. Ultimately suffered, got the punishment. Okay. Now there is an interesting case next, right? 2001, 6 SCC page 1. You know, this is interesting. You know what? Just come to first paragraph 1. Yeah. Look at this. The legal profession is not trade or business. I think we have covered all this already. That's why we are not connected with the, the result part of it. It is a noble profession, etc., etc. But let me tell you in brief. This is a case, this advocate, this genius, he used to give advice something like that, okay, you are going to transfer some property, you don't have to pay stamp duty, etc. Okay, you want to go for a divorce, why go for a court? Come, notarized affidavit, both of you are divorced. So the great gentleman who is to give a short solution, and the client who might have gone to the other advocates and he might have said, look, it requires a 10,000 rupees, and he said, no, I will do it at 50 rupees. So something like that situations. So remember, as I said, I mean, it's not a case of that you have to use your subjective decisions whether your opinion is right or wrong. You know that if someone wants to get a divorce, you don't do an affidavit and say that hereby I declare that. You have to file a petition before the district judge. You know the law on that. Okay, this is on that. Now next, this is relatable to that. Oh, he is not there. Your friend, he started with. That in a safety valve, I said there is a, we began with, if you against the judicial officer, if you want to make a complaint, something like that, I said that there is an example I will give you. This is that example. Mohit Chaudhary's case, 2017, 16 SCC, page 78. This is a case where the AOR, Advocate on Record, he wrote a letter and we got a suspension of paragraph 33. And remember, please remember paragraph 34 and 33. 33 and 34, very short, but very smart vaccination you will face. Just read it. It was a case of that Advocate on Record who wrote a letter. When a contempt proceeding was started, he withdrew by filing an affidavit. Even then, he faced a suspension. And now 34, Supreme Court is saying, for all the advocates. So be careful, be cautious about it. That's what I said. Just because there is a right and everything they are prescribed, you don't decide yourself that, okay, this is wrong and write a letter, everything. Maybe sometimes what happens, a client tells you for some reasons. Don't get swayed by that. Next is 2013 11 SCC 435. This is the case. You can straight away come to paragraph 20. Without authorization, filing wakalat. Paragraph 20, just read first within 4 lines. Filing wakalat lamas without any authority and later on filing fictitious compromises. So let us go to, I'm moving little fast, right? For all of us. 2011 6 SCC 86. This is, just read it, you can just write paragraph 38 to 41, correct? You don't have to get it now. It is, you will find a lot of prescriptions on ethical standards. So anytime in your professions you find any difficulty, you can just have a look at that paragraph 38 to 41, it will give you a clear-cut idea. Okay. Next one you can take 2011 1 SCC 688. This is, remember you have to deal with, there are two things. You just look at this. You know, we have to be very fearful, for that part is there. First you can see paragraph 24. This is regarding, before you go to, let me tell you this thing. As I said, this is a, I think this phenomena is now maybe more. Like, if something comes up in the newspaper, most of us have a tendency to book a seat on the good side. In a sense, that yes, I am also with you, it is so bad, that kind of thing. So therefore, how can I take the brief of that person when he comes to court? So this is a case where paragraph 24 you will see that, let us read paragraph 24, right? Professional ethics require that a lawyer cannot refuse a brief provided a client is willing to pay his fee. I think we have covered, look, that same thing Supreme Court is just echoing. And a lawyer is not otherwise engaged. Hence, the action of any bar association in passing such a resolution that none of its members will appear for a particular accused, whether on the ground that he is a policeman or on the ground that he is a suspected terrorist, rapist, mass murderer, etc., is against all norms of the Constitution, the statute and professional ethics. It is against the great traditions of the bar, which he has always stood up for defending persons accused for a crime. Such a resolution is in fact disgrace to the legal community. We declare that all such resolutions of the Bar Association in India are null and void. Up to this part. So remember that tomorrow if you appear for someone, after seeing that there is a resolutions by the bar not to appear because the bar took a decision, it is so heinous a crime, you having taken up the responsibility of defending that person's is absolutely right, and if you are in difficulty, you can bank on this judgment for that purpose. In fact, there are beautiful paragraphs are there here in paragraph 21, etc. Some films have been referred. So, as and when in coming 25 or more than years you have the occasion, you please read that. It will help you. You know, I was saying about that affidavit divorce part. On that, again, there is a 1984 2 SCC 556. This is Y85. Yeah. Others seems to be knowing what I am going to show. Despite of the fact I sent him the soft copies only by mail last night. So, there paragraph 8 to 10. We need not read that. Now there are some others judgments, you just keep it with you. It involves various questions related to right to practice, etc. It's really not more of an ethics part. It's not immediately required, right? So you can keep all the judgments, soft copies. Now we would be ending. I just thought look at this. There is one of the articles we hardly see. That is Article 51A. Please write that. This is because since we are advocates, there is a general moral dialogues we can have, but there is a prescription also there in the Constitution. Article 51A within bracket G. Remember, these are the fundamental duties. There, first let me read and thereafter I will explain why I think this is a very interesting article. We can think of that. It is to strive towards excellence in all spheres of individual and collective activities so that the nation constantly rises to higher levels of endeavor and achievement. So what I am trying to say is this. Of course, as a human being, you would be, trying to go for, excellence, no doubt about it. But now also simultaneously, you also have Article 51A, that also tells you, that also encourages you. Because you are an advocate, you can take note of that. Even constitutionally, you are supposed to be better and better and better. Now, while we are trying to be better and better, strive for excellence, we may have a lot of bumps. We may find a lot of difficulties on our road. So those difficulties could be for, say, I'm not using the word violations, say plus minuses, some deviations, etc. of this ethics. So once you are sensitized and you have this kind of orientation that I know as a human being, I am not completely divorcing my morality. I have my own morality, I have my own subjective individuality. But at the same time, there are many occasions I find that there is a sync, there is a conformity with my morality with the prescriptions that I have which I am required to follow. Once I follow that, my life becomes smooth. In a sense, my professional life has a smooth sailing. And if it has a smooth sailing, you also fulfill what is sought to be fulfilled under Article 51A. So you become a better lawyer. Of course, a better human being. I think this is the right time for we are eagerly waiting for food. So it was nice having a good conversation with all of you. I hope you had a very, 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 what time, boring time?
No, sir.
No. We had a very good interactions. I did feel that. Because none of you actually had slept. Yeah. Thank you so much.
So with so many guidelines given, how is it that those illegal strikes happen?
I tell you. Give me a super honest answer. All of you are advocates. How many of you have actually read all this statutory prescribed? How many of you have actually read each of the judgments of this? No. Answer is no. So therefore vaccination was needed, right? So I in fact, I felt that I'll be feeling good if I find, because that I don't tell you what to do. I don't tell you, look, this section says it, because it doesn't help. No, it doesn't help, because now you get a bigger picture of it. As an advocate or as a human being, as a citizen, whatever, you know that it's no more a rule, it's a matter of interpretation being done by Supreme Court saying no. And not only no, a 5 judgments of the Supreme Court, followed by the other Supreme Court judgments, followed by the different consequences. You can say, if I am not aware of it, so I will be very brave, just like that. Sometimes you will find some people are extremely brave. Bravery is great. But when you know, some people they are very brave because they don't know the consequences. And sometimes because there is a flaw in the system. Sometimes there is in the entire system they are not aware. It's so serious, I tell you, so serious. This strike, it doesn't happen in Supreme Court, it doesn't happen in Delhi, it doesn't happen in Bombay. So I'm not naming where it happens, but the fact is it happens, and the fact is there are so many resolutions are being passed. Think about other way also. Think because of the large pendency, just wasting a full day. How pathetic. And what do you do on that day? You have already come to court, correct? So you are not spending time with your family, and I doubt how many of them would be eager to spend time with you also. So thereafter you spend some time gossiping, etc., etc., and you actually lose your momentum. Everything has a momentum. Like you are ready to practice, suddenly there is a jolt. Okay, you are ready with the matter. What happens? You are carrying the burden. Look, now I am fine. Like my work is done, the vaccination program is over. I wish that your immunity will work of your own, nothing to do with me. So now I am free, correct? Now I can have a walk with the different. For last night I didn't go for a walk, it was a nice weather here. So I said that fine. So similarly, once you continue something doing, and there is a break, you are ready with preparations, all judgments, and you go to the court, you find the court is not going to happen. So do you actually gain it? You don't gain. You carry the whole burden and you have to read it again little bit. You can't depend on your memory totally. Yeah, it's true. It's there. But I wish that some people actually see it. I wish that some of the advocates actually get sensitized, become sensitive to this thing, that it is no more just the rule, it is Supreme Court is saying, and it is against every ethical part of it to close the court, to stop functioning. That was very, 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 true. But that's the way it is. Yes, yes.